Today we're doing an estate planning case study, married couple with minor children. You ready? Let's go. Before we get to that though, why should you pay attention to me anyway? Who am I? My name is Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Love talking about estate planning and kind of showing you how it works. If you want to talk with us or work with us, you can do so by going to cmslawfirm.com. So let's set the stage for a case study. Talking about a married couple, probably in their, mid 40s. They have two kids, a 10-year-old and a 12-year-old. They own a home. They have about $2 million in total assets. And they want to generally make sure that their kids are taken care of in case something happens to them. It's a classic estate planning case study. This is the type of people that we talk to all the time. And there's a lot of helpful things that you can do to make sure that you're protected, to make sure that your family's protected, and to make sure that your assets are sort of used to their maximum productivity. First things first, what I normally will do is after I get that information, and by the way, generally the flow of assets is everything to the surviving spouse and then to the kids equally, right? And the parents are typically concerned with good reason about what happens if they are gone and how the assets are distributed to the kids. I always ask, are you okay with your kids just getting a check when they turn 18? Most of the time, the answer is no, and I think we can all understand why. Pretty straightforward. Where we usually start when it comes to estate planning with this type of situation is going to be talking about the two different things that estate planning really covers, and that is going to be situation number one, if you are alive but incapacitated. Okay, so think like you're in a car accident and you're in a coma, or you are elderly and you have dementia. Okay, those are the two types of things that we're talking about. The other scenario that we're going to be talking about, by the way, is what everybody pretty much thinks about when you think estate planning. That's when you die. So this first scenario, alive but incapacitated, there's several different things that are involved. They serve to protect you, they serve to protect your kids, and they serve to make sure that the people that you want to be in charge are in charge. The first one is going to be power of attorney. Power of attorney is basically who can step in and manage your day-to-day life financially. Pay bills, pay your taxes, just do those types of things. Typically, this is going to be spouse first. Then you want to have a backup in case something happens to both of you. Number two is going to be medical power of attorney. Very similar to the sort of financial power of attorney, except it's specifically for medical decisions. Same thing, typically spouse first, then you'll have a backup in case something happens to both of you. In many cases, the medical power of attorney backups are different for each spouse because they will usually include someone in their family. Number three is healthcare directive. This is if you were in a vegetative state, do you want to pull the plug or not? This just tells your medical power of attorney what you'd want to do if you were in that situation. Clears up any confusion, right? Makes it clear. That way families aren't fighting, nobody's doing anything. Pretty straightforward there. This, by the way, healthcare directive is also referred to as a living will by some people. Now, what if something that happens to both of you, we want to make sure the kids are covered. This is where minor power of attorney and minor medical power of attorney come into play. The way I would describe these would be temporary guardianship documents. Who is in charge while both of you are gone? Who can do parental things? Sign a field trip slip, take your kids to the dentist, do those kind of adult things and have the legal authority to do them. That's what we're trying to do here. And those usually just are in effect until one of you can get back on your feet and take over. That's the alive side. Phase two is when you die. We have a couple different things there. Number one is going to be disposition instructions. These are like burial instructions. You want to be buried, cremated, composted. Where do you want to go? You want to go into space? You want to go in the ocean. Where do you want to go? I say try to make it as tricky as possible for your people. I'm joking, by the way. Number two is going to be will. Will is going to name your executor, also called personal representative in Washington. Will is going to name long-term guardians. So both of you are gone. Who steps in and fulfills that parental role? And then will also tells the world where you want everything to go. All of these things together, in many instances, would be enough to sort of give you the foundational needs that you want. However, when you have minor children, we have a problem with the will. Pretty big problem. The will only does direct distributions. So for example, if you have a 10 and a 12-year-old, in the example that we've been using so far, and both of you are gone, and you have this $2 million, that money is basically just going to be put into an account for the kids. When the kids turn 18, they are going to get a check for $1 million. For most people, like I talked about earlier, this is not a great solution. This is not a great outcome. Most kids are not great with money. Here's the other thing too, by the way, that I always mention. Even if you think your kids are just so responsible and wonderful with money, there's one thing that they don't have that is critically important to someone that comes into some money or has money. And that is life experience, evaluating opportunities that are going to come to them. Also life experience, evaluating friends and who's coming in to this friend zone. In a lot of cases, money attracts investment deals that are terrible, and it attracts friends that are not the friends. And so these are other things to consider when you think about whether or not you want to give your assets outright to your kids at a young age. The solution to this problem is going to be a revocable living trust. The way I usually describe a trust is like a box. You're going to create this box, and the two of you and your spouse, are going to be everything to this box while you're alive. You are the trustors, the creators of the trust. You are the trustees, the managers of the trust, and you are the beneficiaries of the trust. While you're alive, you can do whatever you want when it comes to this trust. Change the trust, move things in and out of the trust, you revoke the trust, you're the boss. What's nice about this is when you create this trust, you typically will put your house into the trust. This is a probate avoidance tool, which is a second benefit of the trust in this case. Probably the secondary benefit when you have minor children, but still the benefit. What happens here is you put your house in the trust. You can still sell your house, refinance your house. You can obviously live in your house. You can do whatever you want with your house. But when you die, because the trust owns the house, it continues to own the house, and there's no need to transfer that ownership interest. So there's no need for probate. So that's how you avoid probate with the trust. What the trust also allows you to do, though, is to provide long-term distributions over time to your kids, really in whatever manner that you want. Tremendous flexibility with how you do distributions with a trust. So, for example, you might say something like, if we die before the kids turn 18, our house is to remain in the trust and made available to the guardians and our kids to live in if they need it. You may say that. When they turn 18 or 22, or when they move out of the house, then the trustee can decide whether or not to keep the house, sell the house, whatever they want to do. In the meantime, with liquid assets, you can say something like, until the kids turn 25, the trustee will make distributions on a discretionary basis for health, support, education, maintenance, basically at the request of the guardians, if your kids are under 18 when something happens to you, or by your kids themselves if they're over 18. The way it basically works is they ask the trustee, hey trustee, I'm going to college, I need some money. Trustee will pay for that, right? Clearly education. Hey trustee, I'm going to college, I need a car, I'd like a Ferrari. Trustee would be like, you can have a Jeep. Okay, so you have oversight there, you have opportunity to use these funds for good. You don't have to worry about what's going on. Like for example, in my trust, or the trust with this married couple, you might say at 25, they can have a third just by asking. If they want to buy a house, start a business, do something like that, they can do that. When they turn 30, they can have 2/3. When they turn 35, they can have as much as they want. You can do any variation on this thing. So you have a lot of flexibility when it comes to distributions. That's it. That is what I would consider to be sort of a foundational estate plan for a married couple with minor children that has, decent assets, probably $1 million and up. I would strongly consider this. Touches all the bases, puts all the people in charge, protects you, protects your assets, protects the kids, and totally comprehensive solution. Okay, that's it. That's our case study. See, not so bad. Under 10 minutes, we got this done. If you like this and you want to talk more, cmslawfirm.com, you can go to set up a time and talk with us. Happy to do that. And that's it. As always, though, I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. Appreciate you. And I will talk to you again soon. See ya.